Good morning, good afternoon, and good evening, everyone, wherever you are listening to us from around the world. I am very pleased today to welcome Luiza Sato from the law firm TozziniFreire in Brazil. Luiza is a very dear friend of ours, not only because she's a fundamental member of our alliance, but also because she is the chairperson of Privacy Rules. We have this very limited time for our Privacy Espresso to bring to you news from all over the world. In this moment, everyone knows that privacy of teenagers and children is particularly important and is subject to legislative reform all over the world. So today we are talking about what happened recently in Brazil. And so, Luiza, I really would like you to introduce yourself briefly and to tell us a little bit about the Digital ECA and actually what it stands for that was recently introduced in Brazil.
Thank you, Andrea. I'm really happy to be here. So I'm Luiza Sato, partner of TozziniFreire Advogados, in charge of the data protection area. And well, the Digital ECA, it stands in Portuguese for Estatuto da Criança e do Adolescente, Estatuto Digital. And this means that it is the Statute of Children and Adolescents in the digital environment. So as you said, this is definitely one of the most important and fast-moving regulatory discussions in the digital space today. So the Digital ECA, the Digital ECA, it is Brazil's new legal framework focused on protecting children and adolescents in digital environments. One important aspect is that the law does not apply only to services specifically designed to children and adolescents. No, it applies to products and services with likely access by children and adolescents. So what does this mean? This concept is intentionally broad and may impact social media platforms, gaming companies, app stores, operating systems, streaming platforms, marketplace, and several other digital services. And the law establishes a wide range of obligations. Some examples include privacy and safety by design and by default, parental supervision tools, restrictions on profiling and targeted advertising, transparency obligations, risk assessments, moderation mechanisms, and controls regarding harmful or age-inappropriate content. But I would say that the central issue, and probably the most debated one today, is age verification. This topic is particularly important because it is from age verification that all other obligations arise. So once a user's age is determined, the platform can then apply the appropriate safeguards, restrictions, and protections required by law. Additionally to that, age verification is technically the most challenging obligation to implement, as it requires balancing accuracy, privacy, and user experience. And so in Brazil, the ANPD, the Brazilian Data Protection Agency, so no longer an authority, this is new, it is now an agency, became the main regulatory authority responsible for overseeing the Digital ECA framework. The ANPD has already started taking a very active role, especially regarding age assurance mechanisms. There is an entire action plan published by the agency to address this matter. Recently, the authority issued preliminary guidance on reliable age assurance mechanisms, outlining important principles such as proportionality, privacy, data protection, transparency, and all. And last Thursday actually, the ANPD has published a call for contributions on its draft guidelines regarding the scope and general obligations under the Digital ECA to be followed by suppliers of IT products or services. It is open until June the 15th.
Excellent, Luiza. Thank you so much. So the application and the implications are really wide. We are learning from you. You already mentioned some of the challenges. Is there any other challenge that you would like to mention for what concerns what your clients have to do in order to implement the law properly?
Sure, we've heard already a lot of our clients' challenges. So there are several actually. First one, I would mention that there is a significant uncertainty regarding interpretation of this new law, as happens to every new law. Companies are still trying to understand concepts such as likely access and what exactly the ANPD will consider sufficiently reliable age assurance. Second, I would mention that there is an operational challenge. So implementing the digital ECA compliance is highly cross-functional. It involves privacy teams, product teams, engineers, trust and safety teams, advertising teams, public policy teams, and of course the legal departments, all of them working together. In addition to that, the third challenge I would mention would be the global product challenge. So we see this with privacy rules lots of the times. Many companies operate global platforms, and they are trying to understand how to adapt products for Brazil, of course, without completely fragmenting user experiences across jurisdictions. And finally, there is the balancing exercise between child protection and privacy. The ANPD itself has acknowledged concerns regarding overly intrusive verification methods, especially those involving biometric data. So companies are trying to strike a very delicate balance between legal compliance, user experience, privacy, and cybersecurity.
Thank you so much, Luiza. This is very clear, and evidently everyone has to look into the law and receive advice in order to be in the condition to comply with it properly. So talking about it, is the law already in force? And if companies have to comply, and in case of violation, which might be the penalties they might incur in?
Yes, the digital ECA is already in force. The law became effective in March this year. The penalties can be very significant. The framework provides for warnings with corrective deadlines, fines of up to 10% of a company group's revenue in Brazil, which is a lot, limited to 50 million reais per violation, and even which is around $10 million today, and even temporary suspension or prohibition of activities in certain cases. In practice, however, I would say that the biggest immediate risk for companies is not necessarily those financial penalties. It is the reputational exposure, regulatory scrutiny, and the expectation that companies demonstrate good faith efforts toward implementation. This is clearly an area where regulators globally expect companies to move quickly and proactively.
Excellent. Luiza, we are managed to be on time with the one for an espresso, as we can expect from a very good Brazilian coffee. Is there anything else you would like to add for our audiences?
No, I think that will be all for today, Andrea. Thank you so much for having me.
Thank you very much, and thank you all for listening to Luiza Sato from TozziniFreire, leading law firm in Brazil. And we will see everyone into the next episode of the Privacy Espresso. Thank you, Luiza.
Thank you. Bye.